I'm going to introduce Carol Day to give us a legal snapshot. Carol's a lawyer who's worked in the environmental sector for over 30 years with NGOs, including the Wildlife Trusts and the WWF UK. Since 2013, she's worked as a senior environmental solicitor at Leigh, specialising in cases concerning biodiversity, climate change, pollution and planning. She also works part-time on the Aarhus Convention and access to justice in particular for the OSPB. In this capacity, she co-chairs the legal strategy group of Wildlife and Countryside Link, a coalition of some 90 environmental organisations. She's also vice chair of the Environmental Law Foundation. Over to you, Carol, with a reminder to our audience to put any questions for Carol in the Q&A and vote them up, others up if you want to. And any wider thoughts in the WooClap link, we'll be collecting all of these later and feeding it into the closing remarks and into our future work. Thanks.
Thanks very much, Sarah. Good morning, everybody. I hope you can see the slides. I'm afraid I'm a real Neanderthal, so I'm going to be calling on Joseph to be saying next slide, please. But I'm very pleased to be here talking to everybody this morning for what is already turning out from the speakers we've had so far to be a very timely and interesting event. So can we go to the first slide, please, Joseph? Thank you. I've been asked to give a legal snapshot this morning. So what I thought I would do is talk about two cases that I've been involved with on behalf of Leigh in the last 12 months or so. I'm going to mention one or two other cases that might be of interest to people. And I'm also going to talk very briefly about the Planning and Infrastructure Bill, which we've also heard quite a lot about this morning from Victoria already. Next slide, please, Joseph. So starting off with the first case I'm going to talk about this morning. This is the National Farmers Union, NFU, against Herefordshire Council and others. This was a case that the hearing was in December of last year and the judgment came out in March of this year. And it was a challenge to a particular policy in Herefordshire Council's local plan, which was adopted in March of 2024. And within the Minerals and Waste local plan, part of the local plan, there was a very sensible policy, policy W3, which held that proposals for livestock units on agricultural holdings must both, firstly, provide waste management method statements, essentially describing what was going to be done with their waste, and secondly, demonstrate at least nutrient neutrality if within the River Wye or River Clun special areas of conservation. Now, the reason for that the council felt that was necessary because both of those SACs were failing in respect of their water quality objectives, both for nitrogen, but particularly for phosphates. And that is known to be because there's a substantial contribution to nutrient load arising from agriculture in the area, particularly from poultry production. There are something in the region of 24 million chickens, that's 25%, a quarter of the UK poultry production raised in the Wye catchment. Next slide, please, Joseph. Now, following adoption of the local plan, the NFU decided to issue judicial review proceedings against Herefordshire Council on the basis of policy W3. There were 5 grounds for the case. I'm not going to go through them all now, they're very detailed. I'm going to focus on the first ground, which was the ground that our client River Action intervened on behalf of. The other grounds there are for reference, and I know Sarah said at the beginning of the talk that the slides may not be available. I'm very happy for these slides to be made available to people if they'd like to see them so that they can read about the other grounds in more detail if they'd like to. But focusing in on ground 1, there were 2 related propositions that the NFU advanced for ground 1. Firstly, that agricultural activities are generally exempt from planning control. And secondly, that agricultural activities are subject to non-planning regulatory regimes, which are there and established to prevent environmental harm. Next slide, please. Now, in relation to these 2 propositions, the court considered 2 questions. Whether policy W3 in the local plan unlawfully extended the definition of waste as set out in the Planning and Compulsory Purchase Act of 2004 and the Town and Country Planning Act of 1990, by reference to the Waste Framework Directive. And secondly, where agricultural activities are regulated by non-planning statutory regimes, whether planning authorities can assume that those regulatory regimes are operating effectively when determining planning application or policy. Now, the NFU's argument was that natural agricultural materials, as defined in Article 2 of the Waste Framework Directive, are not waste for the purposes of the Waste Framework Directive because they're not discarded, but they are used again in farming processes down the line. And also that any agricultural materials are subject to those separate regulatory regimes which are intended to manage their environmental impacts. And here the relevant regime was the farming rules for water. So it can be assumed that those products, those waste products, will not harm the environment. And in that respect, the reference was made to former paragraph 194 of the NPPF, which says that the focus of planning policies on decisions should be on whether proposed development is an acceptable use of land, rather than the control of processes or emissions where they are subject to separate pollution control regimes. Planning decisions should assume that those regimes will operate effectively. Now, River Action's argument, as I say, River Action applied to intervene on ground one and they were granted permission to do that, was that the exclusion of waste in Article 2 of the Waste Framework Directive is made expressively subject to the fact that there will be no harm on the environment. And secondly, on the assumption that regulatory approaches are preventing environmental harm, is actually contrary to the evidence in the Y catchment that the spreading of chicken manure is causing environmental harm. So there's a lot of evidence to show that it was causing harm, or at very least the real risk of environmental harm. And it's worth noting that the Secretary of State adopted River Action's submissions on ground one. Next slide, please. Now, the judge found for River Action on both limbs of their argument. The judge, the Honourable Mrs. Justice Leigh, found that the purpose of the Waste Framework Directive is to reduce and prevent environmental harm, and the exclusion of waste in Article 2 is made on the basis that there will be no environmental harm. And this is the bit where I think some of the Herefordshire councils punched the air in delight in the hearing. An approach which assumes no environmental harm on the basis of a regulatory regime which beyond any doubt had failed to protect the environment would be contrary to that statutory purpose. So she felt there was good reason to depart from paragraph 194 of the NPPF. Now, that judgment finds on the reasoning of Thornton J in another case, Vanbrugh Court Residents and London Borough of Lambeth, in which the court held that the local planning authority can place reliance on the effective operation of regulatory regimes when looking at planning applications, but it can't ignore the issues. It must satisfy itself that that regulatory regime is capable of operating effectively, and if it can't satisfy itself of that fact, then permission should be refused. Next slide, please. So the conclusion is that the law now recognises that the presumption that other regulatory regimes operating effectively is a rebuttable one. In decisions regarding both specific planning applications, that's the Vanbrugh Court case, and in general plan making, this case, the NFU case. And the judge dismissed the application, the NFU's application on ground one, but in fact she dismissed the application on all 5 grounds. Now, very importantly, River Action wrote to a number of different players after this judgment. It's a very significant judgment. So they wrote to all local planning authorities, together with Sustain and Food Rise and Compassion in World Farming, to raise awareness about the findings of the court case and generally informing people what had happened. But they also wrote to various government departments in the other devolved administrations and to the statutory agencies in the devolved administrations to bring their attention to the judgment. And in the detail of the slides, I talk about various different things that are following up on that, but there are reviews in place in various different places, including the Welsh Government, NRW, the Environment Agency and SEPA, and some of you will obviously know a lot more about that. Next slide, please. So the second case I'm going to talk about, these cases, the following bits are much shorter, is a case that was taken by a lady called Alison Caffin. This is all of us standing outside the court in, oh, can we go back to that one, please? Sorry, Joseph. Standing outside the court in Cardiff. I just wanted to point it out at Alison Caffin, the claimant. She's the lady on the left here in the orange top and the pink scarf over the top. So she was the claimant in this case. Next slide, please. So as I say, this case was taken by Alison Caffin. She's actually a board member also of River Action in 2024. And she challenged Shropshire Council's decision to grant planning permission to LK Cook & Sons, the interested party for an intensive poultry unit housing some 200,000 chickens. Now, Alison's case, there were 4 grounds and there were a number of different sub-grounds within that, 2 of which were upheld by the judge, the Honourable Mr Justice Fordham. Now, the first ground concerned the assessment of likely indirect effects for the purpose of the environmental impact assessment. Now, Alison argued that the planning authority had failed to look at both the failed to assess the environmental impacts of spreading manure, very importantly, in both raw form and digestate form on third-party land for the purposes of the EIA. In particular, she argued, the nitrogen and particularly the phosphate content of the manure posed a likely indirect effect on watercourses in the Severn catchment. Now, the judge held that the EIA did adequately assess the impact of the raw manure and that a planning condition designed to prevent the spreading of raw manure by providing for it to be taken away to a licensed treatment facility was lawful. Next slide, please. However, the judge concluded that the planning authority had lawfully admitted an assessment of the digestate impacts, and he referred back to the Supreme Court of Finch for 2 applicable criteria as a matter of law. Firstly, the principle of causation. He held that the effect of something must be causally connected to the proposed development, and that isn't just limited to the direct or immediate consequences. There's a wide causal reach. And the test is whether the effect is likely to occur, with no requirement for it to be part of the proposed development. Secondly, the assessment must be capable of being, the impact must be capable of being meaningfully assessed. This doesn't require absolute certainty or precision, but there must be a sufficient evidential basis to support a reasoned conclusion. And on that basis, the judge found that the planning authority had failed to assess either limb in the Finch test in relation to digestate. Remember, not in relation to manure, but in relation to digestate. And in particular on causation, he held that anaerobic digestion of raw manure to digestate didn't break the chain of causation. There was no document in the EIA recording that the planning authority had looked at that issue, and in the absence of that, they had failed to carry out a legally adequate assessment. Next slide, please. Now, the second ground of Alison's case concerned cumulative assessment and the relevance of parallel control regimes. Alison also argued that the planning authority had failed to conduct a lawful in-combination assessment under the habitats regulations because they'd only looked at pending planning permissions but not environmental permits. And the judge held that if there had been an application to vary a project for a permit, for example, and there were some examples of that within the catchment, that could have produced new cumulative effects that were capable of being assessed. And because of that, the planning authority had failed to follow its own guidance and misdirected itself as to its statutory duty. The court also rejected Shropshire Council's reliance on the MPPF to justify a lack of consideration of the permits. While the MPPF states that planning authorities should assume that those regimes operate effectively, overlaps with the previous case we've just looked at, the Supreme Court case of Finch confirms that this can't be used as a reason to confine or limit the scope of an assessment that the authority is required to undertake. Next slide, please. So to conclude, really on that, the judgment confirms that there is continued emphasis on full and proper decision making in planning environmental decisions, and it clarifies further the scope of environmental assessments required under EIA and HRA. It reinforces that in assessing not only direct impacts, but also indirect and cumulative impacts, authorities must record and be able to evidence their assessment and any exercise of the evaluative judgment they've undertaken. The existence of a parallel regulatory regime doesn't relieve the authority of the duty to fully assess the proposed project and its potential impacts. And it's really interesting to note that in this case, the court focused on real world impacts and implications and the broad purpose of environmental protection, rather than taking a very narrow and technical approach to in-combination assessment. And I've just included a sort of a final picture there just to show before we went into court, we actually had a libation ceremony, which was undertaken by lots of people involved in the Severn and Wye catchment area, and that we were all actually blessed before we went into court. And we took that vial of Severn water into court with us, and we had that sitting on the front of the bench in front of the judge all the way through. Next slide, please, Joseph. Very briefly, just to mention a couple of other cases we've been aware of this year that might be of interest. The first one was taken by Wild Justice, and it concerned an outdoor co-steering centre in Pembrokeshire. That case concerned the availability of evidence that was available for people to take account of as part of the decision-making process. The court found that the failure to include a draft breeding bird survey that was undertaken by NRW in 2024 as a background paper so that people could make reference to that in their objections was a failure to had caused prejudice to people in that decision-making process. There was also a failure to have regard to a mandatory relevant consideration about the impact on the nearby SSSI, and the decision was quashed in that case. Another case which I thought might be of interest is a case taken by, not by us, by Animal Equality. It concerned a very large fish farm in Lincolnshire. And in that case, I understand the planning committee had been told that they did not have to take account of animal welfare concerns in their decision. And the court in that case, they dismissed the application, but they did make quite an interesting finding that the recognition that animal welfare concerns are capable of being a material consideration or a matter of law, and that a planning committee is not required to disregard those concerns. I thought that might be of interest. Next slide, please. Now, just moving on to the final area, I know lots of you are going to be much more familiar with this than me. I have been following it from a distance. My NGO colleagues are following it much more closely. And Victoria has already spoken about this a little bit, so apologies if I'm teaching you all to suck eggs. I'm just going to say a little bit about part 3, which has obviously been incredibly controversial. Just the nuts and bolts of it for anybody who doesn't know. Part 3 introduces the concept of environmental development plans, which are essentially to replace the process of assessment for former European sites under Regulation 63 of the HABS regs. Now, the new process will be that Natural England prepares an EDP in respect to protected sites, which is then made by the Secretary of State. The EDP will identify features of that protected site that could be harmed by development, the conservation measures that are required to protect those features, and the amounts of finances needed to cover the costs of those conservation measures. And a developer then pays into a nature restoration levy towards the cost of implementing that plan if they would like to go ahead, or if there's a project or a plan that might impact on that former European site. But here's the rub. When the decision maker decides an application for planning permission, the environmental impacts of the development on any protected feature of protected sites must be disregarded. So instead of being sure there is no reasonable scientific doubt as to the adverse impact of that project or plan from the development on the SAC or the SPA, decision maker must leave that question entirely out of account. And that's of course akin in contrast to all of the very large body of European and UK case law that we've been working to on that issue up to now, cases like Wadensee and Sweetman. Similarly, the developer will not have to apply for a licence for the disturbance of any protected species, whether that's an EPS or a badger, for example. They'll be deemed to be granted one merely by virtue of having paid into the levy. Next slide, please. Now, as mentioned, the current provision, the current situation for SACs and SPAs is that before a planning authority or the Secretary of State can grant permission for a project that might infect the integrity of those sites, they must be beyond reasonable scientific doubt certain there'll be no adverse impacts on the integrity of that protected site. And ironically, this is exactly the permission that the Secretary of State set out early this year in the case of C.G. Fry in the Supreme Court. We haven't had the judgment on that yet, but the Secretary of State's submissions were all around the kind of current protection of the habitats regulations, which seek to protect internationally important biodiversity in a strict precautionary manner. And the Secretary of State was arguing very strongly for the maintenance of the status quo in that case. Now, as a result of Section 20 of the Environment Act of 2021, Before or when a bill is placed in Parliament, a minister is required to make a statement on the front of the bill to the effect that, in their view, the bill will not have the effect of reducing the level of environmental protection provided for by any existing environmental law. And Angela Rayner, in her former role, made such a statement on the face of the Planning and Infrastructure Bill. It might just interest people to know, as an aside, there is a current challenge to that statement that's been taken by Wild Justice against the Secretary of State for Housing, Communities and Local Government. And that is seeking a declaration that the Section 20 statement made that the Planning and Infrastructure Bill won't reduce the level of environmental protection is wrong in law and or irrational, having apparently been made in the absence of legal advice and in the Wensbury irrationality sense for asserting a view of law that no reasonable minister could hold. Now, in that case, the government is arguing that the statement is privileged. It can't be challenged by way of judicial review. There is a permission hearing on that issue, whether the statement is privileged, being held in early November. If permission is granted for that case, it will go on to be heard in substance. But if not, obviously, we'll have to wait and see if Wild Justice want to appeal that. Next slide, please. Coming to the end. Just to say that a lot of the amendments that we have been seeing so far have really focused down on the mitigation hierarchy, which is avoid, minimise, mitigate, compensate. You'll be very, very familiar with that. It's been the cornerstone of effective environmental planning for many years. The EDP process enables decision makers to bypass avoidance and move straight to compensation with no statutory duty to consider less harmful alternatives. The OEP has expressed concerns. Their view is that the mitigation hierarchy must be applied if government is to meet its own commitment not to dilute environmental safeguards. There have been a number of different amendments. I can't go into them all now. The government amendment 247A is seeking to introduce a new test requiring that off-site measures can only be used if they are more effective than on-site measures, and confirming that irreplaceable habitats can't be lost. That is, in the NGO's view, not enough. Without a clear and enforceable requirement to avoid and minimise harm first, then species and habitats will still remain at risk. Final slide, please, Joseph, thank you. Just to finalise by saying the bill is currently in the report stage, as Victoria said. I think the next sitting is the 20th of October. It will then go to third reading. I think after that there might be a process of ping pong. The current view from the NGO sector is, as I've set out, that the amendments that have been moved are helpful, but they go nowhere near to addressing earlier concerns, and they fall far short of what's needed. I think my own view is that this is, it represents a fundamental shift in the status quo. I've been working on the Habitats Directive for over 30 years. My very first job at WWF was working on the transposition of the Habitats Directive in 1992. So looking at the HABS regs when they came in, very involved in the designation of special areas of conservation. And I think we're all very familiar with the certainty and clarity of the existing regime. We know where we stand. And this new regime, in my view, does represent a very significant reduction in environmental protection. I think it's not just a question of resources. I think you can't make a silk purse out of a sow's ear. I was very pleased to hear Victoria saying that she felt there shouldn't be a watering down of the HABS regs. I was slightly concerned at the beginning. She was saying it was more about resources, but I think it was great to hear that, the RTPI view is that there shouldn't be a watering down of those regulations, because I do think they provide a very clear and consistent framework of decision making. Next slide, please. And that's it. Thank you very much for questions. I hope I haven't gone over too much. I think I've gone over time a little bit, but I hope we've got some time for questions. Thank you very much, Sarah.
Yeah, thanks, Carol. That was absolutely fascinating. Yes, we have got a few questions, and we've still got 5 minutes to play with, so that's cool. I have some, but actually we've got quite a few in from the audience, so I'm gonna jump to theirs instead. We had a question from Richard Knightley, who said, do the rulings and principles apply to all developments? For example, if a development causes off-site land contamination risks, directly or indirectly, such as controlled waters, human health outside the use or the red line boundary, does that enforcement action, can enforcement action be taken against the applicant or landowner?
Yeah, it's a good question. I mean, in principle, it applies going forward to future developments, but whether it applies in exactly at all or in exactly the same way will depend on whether a particular case can be distinguished from this one or it can be departed from. So I think it's very much a case of looking at the facts of each particular development. Do the same principles apply, or are they capable of applying? Or is there some reason why that judgment would need to be departed from? And that very often is something that you can only determine when you've looked at it in a lot of detail and possibly even after seeking legal advice. So if you can say that something is on all fours with that particular situation, yes, it will apply going forward, but it will be a kind of each case on its own merit situation that will need to be looked at in detail.
Great, thank you. I've got a question from John Merlis. He says, it appears from the cases you quote that the evidence of harm leads to a conclusion that an activity is unlawful despite it being covered by a regulatory regime. This seems to have very significant wider consequences where the attainment of quality standards is sufficient by itself, even if harm persists. For example, in air quality matters, health protection is not guaranteed by the attainment of air quality standards. Is this a correct reading of the consequences of these cases for others?
I think the really important point, John, is that it's not that it's more about looking to see whether those regimes are operating effectively, and it's about the confidence that the decision maker can place on those regimes. If they look at them and there's no evidence to suggest that they're not operating effectively, they can absolutely be relied on. But the important point in the NFU case was that there was lots of evidence to show that the farming rules for water were absolutely failing in their objectives. And that was something that nobody really in the courtroom disagreed with. So I think that, the key question for decision makers for any planning authority would be, if there's credible evidence out there that something isn't working, then you would need to actually satisfy yourself. And this is what the judge was saying: get into the issues, get into the facts of it. But if there's no evidence to suggest that, then you are fine to rely on it.
Great, thank you. Oh, the questions are coming in fast and furious now. I've got one from David Rudland, who asked, does the fact that hearings were held in the Cardiff court for a case involving an English authority cause any conflict regarding Welsh English environmental law? And for a border river such as the Wye, is there any potential leniency one side of the border than the other?
Oh, that's interesting. In terms of England and Wales, no, not at all. We have one legal jurisdiction for England and Wales, so the judgment will apply. It would apply throughout the UK, actually, but particularly within England and Wales, it is one sort of holistic jurisdiction. In terms of differences between the border, I don't know in detail. I mean, the slide that I put up, which showed the follow-up action from River Action, you'll see that obviously they had written both to the Environment Agency and to NRW. I think from memory, in both of those situations, there is a review underway. So I don't know whether that indicates that there are, similar or the same level of problems in both. I actually wasn't aware that the review was underway in England until I actually went onto the EA website recently in regard to developments on the Isle of Wight and found that was the case. But I don't know. I mean, I can certainly find out about that from River Action. They would be very aware of that, but I'm afraid I don't have any more detail than that. Yeah,
it's an interesting point where you get them kind of adjacent, but with common resources. And then we've got a question, really asking for your comment. The case studies addressing parallel control regimes are useful. In air quality, we have environmental permitting regulations to manage emissions from combustion plant. In some cases, they aren't as tight as they could be or should be to minimise harm. And I wondered if you had any thoughts on that in light of kind of the other work you've been doing, pushing back on new legislation.
Yeah, absolutely. So, I mean, is the question around how those regimes could be made to operate more effectively? Is that,
Yeah, yes, I think it's, I think it's to do with, do you think that the commenter is correct? And do you think we should be pushing for more of it? Do you think we've got a chance of getting stronger protections there?
I don't know. I mean, I have to confess, it's not my area of expertise. I mean, I think if it's a question of, there's really a question, isn't there, about are the existing regimes effective, and are they being enforced as well as that we would like them to be enforced? If it's about the quality of the actual regime, there's very little that can be done about that really, other than then actually sort of lobbying the government to be producing, to be strengthening those regulations. I don't know how the appetite within government is for that at the moment. I mean, obviously, everything we're seeing is on a sort of anti-trajectory on that front, really, certainly with regard to things like, obviously I talked about the planning and infrastructure bill and looking at the sort of weakening of that. It goes back to the point that Victoria was making, I guess, about, how committed the government is to this particular agenda. If that isn't felt to be something which is going to frustrate the target to meet homes, it might be something the government has an appetite for. If it is going to be something which is going to cause problems down the line, I wouldn't say that you've got an awful lot of hope of getting that changed. If it comes to enforcement, I mean, that's very often a question of resources, I guess, isn't it, as well?
Yeah.
I mean, I suppose the danger is there that if enforcement isn't being done effectively, that there's always the risk of challenge. But I do know that in enforcement cases, there is a high degree of discretion on the enforcement body. And so those cases are quite difficult to bring.
Yeah, we do need to move on, but I wanted to ask you one quick fire question, which is that to an environmental specialist, a lot of the case law is quite intimidating. And I was just wondering if you could give me a very short response, because we do need to move on. How do we help environmental specialists in local authorities, NGOs, consultancies, developers, and planners, based on what Victoria was saying, to not fear the legal details? Obviously, in an ideal world, we'd all have access to environmental lawyers on a daily basis, but there's getting a lot of pushback to either put something in or take something out in terms of planning conditions and so on. Do you have any kind of off the top of your head thoughts on that one before we move on?
It's an interesting thought, isn't it? And I mean, I think keeping on top of the case law particularly is very difficult, isn't it? Because it's changing all the time. And both of these cases, both the Shropshire and the NFU case that came out this year, really interesting and important. And obviously, it's a question of making sure that everybody is sort of fully up to date. I mean, I think, one of the things that River Action is thinking of doing, it certainly wrote to all the local planning authorities to say, these are the implications of this judgment. You should be aware of it. It's really important and significant.
Oh, great.
So, I mean, perhaps more of that. I mean, that's definitely something that I can take back to the groups that we advise and work with. Whether there would be a very effective and simple way that some of those cases and the implications of them could be made more available and accessible to people. We'll have to think about that, because I agree, it's really important.
Yeah, I think that would be fantastic, and maybe we can have a chat with Ellie as well about what we can do here at EPIC. Fantastic. Thank you, Carol. That was really interesting.